Colleges, Muftis and Judges Part 2. The court, it seems, would usually meet in the judge's house, where, in all his functions, the judge had the assistance of a deputy, who could conduct proceedings in his absence, and a clerk or clerks who kept records, and could also carry out investigations outside the courtroom. The judge's registers also record, after each case, the names of a semi-permanent group of witnesses to the proceedings and appos. Their function is not, however, clear. They seem to have acted as a collective memory of the court's proceedings, and might, for example, be asked to check the validity of documents. As people with a knowledge of the locality and its inhabitants, they perhaps also offered advice on cases, as well as keeping a check on the probity of the judge. A person bringing a matter to court would therefore encounter not only the judge or his deputy and the clerk of the court, but also a group of permanent witnesses. 24. A judge's functions, however, were not all strictly legal. Court registers and records of the Imperial Council show that the Sultan addressed commands to judges to perform a very wide range of duties. It was, for example, primarily the judges who were responsible for levying oarsmen to serve in the galleys of the imperial fleet, or to organize the collection of provisions along the army's route of march. A sampling of the decrees which the Imperial Council issued to judges in June and July 1564 gives a sense of the range of their duties. The judge of Chernomyn receives a command to levy for campaign the raiders of Rumelia, after their governor has reported that they have not mustered for duty. The judges of Kilia and Ackerman were to oversee the sale of sheep to the drovers coming from Istanbul to bring them to supply the capital. The Sultan orders the judges of Plovdiv and Sofia to allocate craftsmen and tradesmen, a butcher, a cook, a saddler, a cobbler and others, to the army of Rumelia, under the command of the Governor-General. The judges, whose districts fall along this route, are to secure provisions. The judge of Antalya was to secure a galleot to ensure the speedy passage to Egypt of a messenger carrying an important decree from the Sultan to the Governor-General. It seems, in fact, to have been primarily the judges, in both their judicial and administrative functions, who provided support and continuity for the Sultan's authority. The role of muftis in the Ottoman legal establishment is more difficult to define. The mufti of Istanbul rose during the 16th century to become not only the chief mufti, but also the senior figure in the religious and legal hierarchy. 25 Other muftis were not so prominent. It seems that in the 15th and 16th centuries, it was the college professors who acted as muftis. Bayezid II, for example, stipulated that the professor of the college which he founded in Amasya in 1486 should also function as mufti of the town. 26 Atayi's biographies, however, give the impression that, from the mid-16th century at least, the Sultan also appointed salaried muftis to important towns and cities, such as Thessaloniki, Damascus or Rhodes. There seem, however, to be no surviving records of their activities, and appointments as mufti seem never to have formed the major part of a career. The muftiships that Atayi records usually appear as interludes between postings as judge. Atayi also makes it clear that college professors, officially or unofficially, continued to act as muftis. A law book of Aleppo, dated 1570, provides an example. The text records how a problem arose when a certain Mehmed Chelebi was making a new cadastral survey of the Sanjak. During the course of his work, a group of landowners and managers of trust land came to him to complain that their lands paid tithe, whereas other private and trust lands did not. If, they complained, it is lawful to levy tithe, why is it not taken from all such lands? And if it is contrary to the noble Shari'a, we beg that it be abolished. The reaction of the surveyor was to seek an opinion on the matter from the professor of the Huzrev Pasha College in Aleppo, who issued a fatwa ruling, the canonical tithe is binding on all of them. The surveyor then forwarded this fatwa, as it was, to the palace and received a sultanic decree based on its ruling: you should collect the canonical tithe from all of them and take it for the treasury. This was a case of a government official seeking a fatwa from a mufti, which subsequently formed the basis of a decree. Judges could also consult muftis on questions of law, as could members of the public on any question whatsoever. In this respect, muftis played a vital part in adapting the inherited norms of Islamic law and religion to the problems of contemporary society. 27 From the Ottoman Empire, however, it is only the fatwas of the chief muftis, the mufti of Istanbul, that have survived in large numbers. Of the provincial muftis, little is known, and service as mufti in the provinces seems never to have formed a distinct career, as did service as a judge or professor. It seems that small-town judges and college professors in general remained within their own profession. Nonetheless, Atayi's biographies record many cases of teachers receiving appointments as judges and vice versa. A certain Mullah Abdullah, for example, entered The teaching profession as a candidate of the chief mufti, Zakaria, Afanda, d. 1593. After progressing through the system, he became, in 1624, professor at the Suleymaniye College in Iznik, with, undoubtedly as a consolation for a blocked career, the grade of the 8 colleges in Apas. In the following year, he left the college to become judge at Tyre. A slightly earlier biography serves to show how a man could serve as teacher, mufti and judge during the course of a single career. Molla Mari Fetullah began a teaching career as a candidate of some learned men in Apas. By 1584, he was professor at the College of Kuk, Sikmis near Istanbul. 5 years later, he accepted a post as mufti of Rhodes. Then, in 1590, he received a promotion to become judge of Damascus, one of the great mullahships of the empire. It was presumably the prestige of this post that led him to refuse what was in effect a demotion to the judgeship of Erzurum in 1595. Instead, he transferred to the College of Sultan Mehmed in Medina. He later transferred to the muftiship of Cyprus, then of Damascus, dying in Istanbul in 1606, while awaiting a new post. In his biographies, Ata'i gives many examples of posts which carried an honorary rank during the incumbency of a particular individual, such as professorships held with the rank of the 8 colleges in Apas, or small-town judgeships held as great mullahships. This indicates that, after the mid-16th century, for most professors, judges and muftis, there was no hope of reaching the top of the profession, and that these ranks were consolation prizes. There were 3 reasons for this. First, the positions at the top of the hierarchy were very few. During the 16th century, the mufti of Istanbul emerged as the senior figure in the learned establishment, but this was only one post. The muftis in the provinces did not enjoy real prestige or influence. The senior judges of the empire were the military judges who sat on the imperial council. But there were only 2 of these, and judgeships of the great cities, that is, mullahships that were not purely honorary, were few. There were only 8 professorships at the 8 colleges and, after the establishment of the Suleymaniye, a few more above this, but not enough to satisfy all aspirants. Furthermore, these elite colleges acted as a bottleneck. To become a judge of a great city, it was usually necessary to have served as a professor at the 8 colleges. To become a military judge, it was in turn necessary to have served as judge of a great city, and the mufti of Istanbul had generally served as a military judge, starting at the 8 colleges. Therefore, there was a strict control over who could occupy the senior teaching and judicial positions in the empire. The second factor limiting a person's opportunity was overcrowding in the system. At the higher level, this led to fierce competition between candidates for posts, and very short periods of office. At the lowest level, it led to the appearance in Anatolia of bands of college students who, with no prospects of employment, took to brigandage as a means of livelihood. 28 Finally, the ambitious would find that a few families already monopolized the top positions. This phenomenon became more pronounced from the late 16th century onwards. The occupants of the post of chief mufti serve as an example. Ottoman tradition names Molla Shamsuddin Fenari as the first to hold this office, between 1424 and 1431. His descendant, Fratricide Mehieddin, was to occupy the same position from 1543 to 1545. By this time, however, the most powerful claimants to the post were the 2 military judges, Abu Su'o and Shahrazad Mehieddin. Shahrazad was the first to hold the muftiship, from 1539 until his removal 4 years later. His successor but one was his rival, Abu Su'o, who remained in office until his death in 1574. His immediate successor, however, was Hamid Mahmud, the son-in-law of Shahrazad. The rivalry between the 2 families clearly continued. Hamid Mahmud's successor but one was Malyalzade Mehmed, the son-in-law of Abu Su'o, and, on his departure in 1582, Shahrazad's son, Haji Mehmed, assumed the office. He was the last of the family of Shahrazad to occupy this position. Meanwhile, the fortunes of Abu Su'o's family continued in his cousin's son, Sunullah, who was 4 times chief mufti between 1599 and 1608. 29 By this time, however, powerful rivals had emerged. In 1598, Mehmed III appointed his and his father's tutor, Sa'd-ad-Din, as mufti. His period of office lasted only the year and a half to his death, but his descendants maintained a family claim for half a century. His elder son, Mehmed, was chief mufti between 1601 and 1603 and again between 1608 and 1615, while his younger son, Asad, occupied the post between 1615 and 1622, 1623 and 1625, and finally between 1644 and 1646. 3 years later, Sadruddin's grandson, Bahai Effendi was appointed mufti. The most successful opponent to the aspirations of the Sadruddin family was Zakaria Zaid Yahya. However, he was himself the son of a former chief mufti, Zakaria Effendi, who had occupied the post in 1592-3, so he too could lay a dynastic claim. 30. From their positions as chief mufti or military judge, the successful members of the learned dynasties could use their patronage to promote their own relatives. Abu Su'o's family provides an example. Thanks to the influence of his father, Abu Su'o's eldest son, Mehmed, received his first teaching appointment at the Qasim Pasha College at the age of 13, with the unusually high stipend of 50 akshas per day. In 1551, at the age of about 26, he was professor at the 8 colleges. His brother, Shamsuddin Ahmed, became, at the age of 17, professor at the college which the Grand Vizier Rustam Pasha had recently founded in Istanbul. Both these sons died young, leaving Abu Su'o with the burden of educating his grandsons. The elder of the two, Abdul Karim, became professor at the College of Mahmud Pasha, according to the biographer Mank Ali, in honor of his grandfather, and contrary to custom and apos. He died in 1573-4, having already in his 20s, become professor at one of the colleges of the Soleimaniye. Abu Su'o's other grandson, Abdulvasi, was, at the time of his grandfather's death, a professor at the Soleimaniye. However, with the death of his grandfather, he lost his source of patronage and, in Atai's words, the swift steed on the path of his prosperity stumbled on the stone of misfortune and apos. His career did not advance until, in 1580, he received the professorship at the new college of the Mosque of Sultan Selim II in Edirne. He died in this city. A few years later, Abu Su'o did not, however, bestow his patronage only on his sons and grandsons. As military judge of Rumelia in 1537, he was able to bring his cousin Jafar to Istanbul, where he embarked on a career which culminated in his 6-year tenure of the military judgeship of Anatolia. Jafar's brother, Lutfullah, was professor at the 8 colleges from 1562 until his death in 1568. His son Sunullah was to become chief mufti. 31 Abu Su'o was in no way unusual in promoting his own family within a political system almost without corporate institutions and where power and patronage resided in families and households. This was the only way to advance a career. Of the positions to which members of these learned families aspired, the judgeship of a great city did not, in essence, differ from the judgeship of a small town. The 2 military judges, however, were members of the imperial council and, as such, participated in government at the highest level, whether through the formal discussions of the council or through informal contacts with the palace and the great men of the empire. On the council, they had particular responsibility for judicial business. This is clear from the notes which the clerks have appended to the drafts of sultanic decrees contained in the volumes which survive from the mid-16th century onwards. These show that the military judges were, in the first place, responsible for submitting to the imperial council letters and petitions for redress that they received from office holders and members of the public. In May 1560, for example, the Sultan, or rather the imperial council acting in the Sultan's name, issued a command to the judge of Bursa to investigate and report on a complaint by the Armenian community against an individual who had been causing trouble in Apos against 2 churches. The draft of the decree carries the note. The military judge of Anatolia submitted it. In the same month, the council received a letter from the professor at the Mehmed Pasha College in Iznik, complaining that someone had unnecessarily built a bathhouse, which was diverting both water and cash from the bathhouses belonging to the trust which supported the college. In response, the judge of Iznik received the command not to allow the construction of any new bathhouses in the town. The note attached to the draft indicates that the text of the decree incorporates the exact wording of the military judge's ruling. The military judge of Anatolia submitted the letter because he recorded his command. On the petition, the decree has been written accordingly. A similar note appears on a decree, also of May 1560, issued in response to a letter from the Sanjak governor of Sultanonu, reporting on the suspects in a complex murder case. The decree, incorporating the ruling of the military judge, orders him and the judge of Eskies, to inflict the acceptable custom, that is, torture, on the suspect, and to report what transpires. It adds emphatically that the suspect should not be killed. Another decree, this time of June 1560, and issued in response to a letter from the judge of Bipazar, orders the execution of a roughneck for raping boys, and of his accomplices if they repeat the offense. The text carries the note. The military judge of Anatolia, submitted the letter, and the decree is registered incorporating his words. And Apos. The military judges were also the main agents in fulfilling another of the imperial council's functions. From the late 15th century, the military class, that is, everybody who received a fee for a salary from the Sultan, came under a separate jurisdiction from the rest of the Sultan's subjects. In criminal matters, the local authorities forwarded the cases to the imperial council, where they came under the scrutiny of the military judges. In November 1559, for example, the military judge of Anatolia ordered the judge of Iznik to execute the Subashi, a Zimat holder with responsibility for maintaining order and inflicting punishments in his district, after it had come to light that he was behind the murder of a group of women on the public road. In July 1560, after receiving a letter from the judges of Iasmend and Bergama, the military judge ordered the Sanjak, governor of Bursa, to torture the Subashi of Bergama, as he was under suspicion of murdering the warden of the castle at Bergama. In September 1560, the military judge of Ramilia ordered the Sanjak, governor and judge of Vidin, to investigate a case where one cavalryman in the Sanjak was suspected of killing another. In all these cases, the executive authorities were to report what happened back to the Imperial Council. In this sampling, it is only the clerk's notes on the draft decrees that make it clear that it was the military judges who presented the matter to the council and took the decision on what to do. The decrees themselves went out in the name of the Sultan. The same sample, however, also suggests that the military judges could issue commands independently, in their own or in the Sultan's name. A note appended to a draft decree of June 1560 records that a command written by the military judge of Anatolia had been given to the same messenger as was carrying the Sultan's decree. Furthermore, a sultanic command to the Governor-General of Anatolia concerning the suspect in the case of the girl called Halima notes that my noble command has been written to you by my military judge, suggesting that military judges could independently issue orders in the Sultan's name. In addition to their responsibility for judicial matters in the Imperial Council, it was the military judges who were responsible for appointing, again in the Sultan's name, professors and judges from among the candidates for office who were in attendance on them in the capital. The system of nominating candidates which Abu Su'o introduced shortly after 1537 seems to have lasted into the 17th century. As members of the Imperial Council, the two military judges occupied the highest executive positions in the learned and legal hierarchy. However, during the 16th century the chief mufti came to surpass them in rank and prestige. Tradition asserts that Molla Fenari, between 1424 and 1431, was the first to hold this office, but it is difficult to trace with certainty even the names of his successors, suggesting that in the 15th century, the muftiship lacked the prestige which it was later to acquire. This was a phenomenon of the 16th century and later, and came about, it seems, partly as a result of the classical Islamic view of the moral superiority of the mufti over the judge, but mainly through the personal eminence of two of the greatest holders of the office. These were Kemal Pasha Zaid, 1525-34, and Abu Su'o, 1545-74. The so-called Law Book of Mehmed II, which, in this section, probably dates from the second half of the 16th century, states unequivocally that the chief mufti is head of the learned profession, and it was, by this time, normal for the mufti to have served previously as military judge. Despite his eminence, the chief mufti possessed no executive powers, and was not a member of the Imperial Council. However, the office itself conferred prestige and the chief muftis moved in the highest political circles, often enjoying access to the Sultan. Abu Su'o, for example, was a confidant of Suleiman I. Sa'ad-ad-Din had been the teacher of Murad III and Mehmed III and remained an advisor to both. His son Asad became father-in-law to Osman II, 1618-22. With these connections, the muftis wielded influence in politics, but this was not their formal role. The public function of the chief mufti, like that of his more humble counterparts, was to issue fatwas in response to legal and other questions, which anyone from the Sultan downwards might ask. His status as the most eminent interpreter of God's law was such that even the Sultan had to defer to his opinion, and the authority of his fatwas was such that, from the time of Kemal Pasha Zaid's period in office, it became customary to select and issue them in edited anthologies. These volumes of fatwas served not only as edifying reading, but also to help judges and others who were seeking guidance in the solution of legal problems. Before the muftiship of Abu Su'o, the process of writing fatwas was informal, as is evident from an account of the chief mufti, Ali Jamali, 1503-25, which appears in Tashkopruzade's volume of biographies of Ottoman learned men. He used, Tashkopruzade writes, to live on the top floor of his house, where he had a hanging basket. The questioner placed in it his question written on a piece of paper and agitated it. The said mullah would then pull up the basket, write his answer and drop it down to him. This and other informal procedures clearly limited the number of fatwas which the mufti could issue, and it was to speed up the process that Abu Su'o, mufti from 1545 to 1574, reformed the system. From his time, until the abolition of the fatwa office in the 20th century, the question no longer went straight to the mufti, but instead to the mufti's clerks, who were experts in law and the art of legal formulation. These rephrased the question according to a standard format and passed it to the mufti, who would write his answer below the question and add his signature, ready for the questioner to collect. Abu Su'o's system speeded up the process to the extent that his clerk, Ashik Chalabi, was able to recall how Abu Su'o began writing answers after the performance of the dawn prayer and was granted completion by the time of the call to afternoon prayer. He counted them and, on the first occasion, 1412 and, on the second occasion, 1413 fatwas were answered and signed in apos. In the following century, the system became more sophisticated as the skills of the clerks increased. By the end of the 17th century, it was normal to draft a question in such a way that it required no more than a yes or no answer, leaving the mufti to add no more than a yes or a no and his signature. Provided the clerks reliably sorted the fatwas into a yes pile and a no pile, he did not even have to read the question. 32 It was thus the permanent staff in the mufti's office, rather than the muftis themselves, who maintained standards and continuity in issuing fatwas, and who subsequently collected and arranged the fatwas in anthologies. The chief mufti's office, like the judges' courts, was open to anyone who was physically able to present themselves with a question. However, since fatwas are, in principle, generalized statements of the law rather than judgments on particular cases, in format they are strictly anonymous with specific details of name, time or locality removed. This makes it difficult to guess who posed the original questions and in what circumstances. However, many must have come from members of the public, wishing to settle a query or dispute, or seeking a fatwa in order to strengthen a case which they were taking to court. 33 Others must have come from judges seeking guidance in settling a lawsuit or other problem. In the following fatwa, for example, Abu Su'o seems to be answering the question of a private individual wishing to know the correct procedure for slaughtering animals, probably at the festival of sacrifice. When a slaughter animal has to be slaughtered, how many legs should be bound, and which should be left free? Answer: 3 of its legs are bound. The right rear leg is left free, and it is laid on its left side. The following, however, seems to have come to Abu Su'o from a judge seeking a solution to a difficult problem. X produces evidence that A has been his wife since such and such a date. Y also produces evidence that she has been his wife since the same date. Which piece of evidence is acceptable? Answer: so long as the dates are the same, neither is acceptable. The two pieces of evidence contradict each other. And apos. The authority of the muftis was such that even sultans and men of state felt the need to consult them on the legality of certain political actions. There are fatwas, for example, which serve to procure the execution of Sheikh Bedruddin in 1416, issued in this case by a Persian mullah, 34, or to justify the 16th century wars against the Safavids, Suleiman I's execution of his son Bayezid, the attack on Cyprus in 1570, in breach of a peace treaty, 35, or the deposition of sultans in the 17th century. In these cases the fatwas have exactly the same format as those dealing with more trivial matters, with the questions and answers couched in the same anonymous language. There can, however, be no doubt that in these instances, the muftis knew exactly the reality of the situation on which they were delivering an opinion, and in almost all cases were prepared to give the sultan, or other authority, the answer he was seeking. The situation by the 17th century was that if they refused, they were likely to lose their position. But sometimes perhaps, the English consul, Sir Paul Riceout, commented in the 1660s, queries are sent from the Grand Signior to the mufti, which he cannot resolve with the satisfaction of his own conscience, and the ends of the sultan, by which means affairs important to the well-being of the state meet delays and impediments. In this case the mufti is fairly dismissed from his infallible office, and another oracle introduced, who may resolve the difficult demands with a more favorable sentence. If not, he is degraded like the former, and so the next, until one is found apt to prophesy according to what might best agree with the interest of his master.